Welcome to today's webinar, The Mongoose Method, Rebalancing the Scales of Justice with Tactical Training in Trucking Litigation Defense, presented as a public service to the trucking industry by PrePass, the leading way station, bypass, and toll payment service provider in North America. I'm Jay Cohen, and I'll be your moderator for today's event. I encourage you to ask questions during the webinar at any point, and we will try to answer them all. However, if we do not get to yours, don't worry, we will send you an email response after the event. Our presenters today are Paul Enos, CEO of the Nevada Trucking Association, and Dr. Bill Kanasky, Jr., Senior Vice President of Litigation Psychology at Courtroom Sciences, Incorporated. Now, I'll hand it off to Paul.
Hey, Jay, thank you very much, and greetings from the Golden West. I'm right here at the world headquarters of the Nevada Trucking Association in Reno, Nevada, and very blessed. I'd like to thank both Heavy Duty Trucking and PrePass for giving myself and Dr. Kanasky this opportunity to speak with you all today. We're going to talk about some pretty fundamental concepts and how they're affecting our industry, and of course, justice. It's a big deal. It's something that we have been talking about throughout human history. On a historical level, our first written code that was meant to be that arbiter of justice, of course, was Hammurabi in Babylon. And, there it is right there. Of course, we also have the mythological Lady Justice holding the two scales with her sword and blindfolded. And then we also have the biblical King Solomon, who would decide whether a woman was the true mother of a baby or not. So we have justice throughout so many different realms of human history. And of course, while our founding fathers may not have been as wise as Solomon, they did create a pretty beautiful thing and a pretty beautiful process, and that's equal justice under law. That's something that I think we all as Americans hold very fundamentally sacred. We want to make sure that if somebody is wrong, that they are taken care of, and we have a justice system to do that. So, folks don't take justice into their own hands. If a trucking company is responsible for a death, for loss of life, for an injury, we're the first ones that want to take responsibility for that, to step up and say, hey, we're liable. We want to make sure that that aggrieved party, that injured party, that they are taken care of. But unfortunately, something sacred and beautiful has evolved into a jackpot justice system. And we've seen that happen in ways that are really gross, with folks staging accidents against our trucking companies here in Las Vegas. My good friend Randy Gilead down in Louisiana, the Pelican State, was involved in some stage accidents where the federal government, the Justice Department, has gone after both attorneys and the perpetrators of staging accidents against trucking companies for insurance payouts. And what we have done with this kind of bastardization of the justice system is we have created a scenario that makes it extremely difficult for trucking companies to operate. 2020, my friends at AdTree, Rebecca Brewster, that is a phenomenal organization, did a study to understand the impacts of nuclear verdicts on the trucking industry. And that's generally defined as something $10 million or higher. We have seen a 967% increase in the size of awards over the last 15 years. And that is pretty frightening, because that is something that has outpaced both healthcare and inflation. Although these are 2020 numbers, so maybe we'll see where that is with inflation. But still, we know that is pretty high. Who does that impact? That impacts our smallest companies a lot more than our larger ones, and we can see that where folks who are operating trucking companies that are less than 5 power units or even less than 25 power units are paying 3 times the amount of insurance. I actually had a guy call me the other day saying, one truck operator, I don't know that I can afford to keep operating anymore because my insurance rates are so high. And of course, when insurance rates go high, what do we see? We see that impact us on the store shelves. We see that impact us as consumers. We know that when the price of trucking goes up, it has an impact on everything. A nuclear verdict hits our industry, insurance companies raise their prices, motor carriers increase their prices, and it's something that we all end up seeing on the store shelves. Those small trucking companies, even though they are being hit with those higher insurance premiums, they're not immune to nuclear verdicts. We saw in Florida last year a crash absolutely devastating. A young man that was killed, but we saw a jury award $900 million to a company that had less than 20 trucks. And these are verdicts that our industry, no matter whether you're a big company or a small company, that we can't sustain. Why have we seen these verdicts go up? Why have we seen this happen? Because the trial bar, the plaintiff's lawyers, are extremely good at what they do. They train their folks. They have multiple resources, multiple training tools that they use to train attorneys, to train their witnesses, to be able to go after companies just like yours. And one of the hallmarks that they have really been able to be successful with is the reptile theory. Getting to that reptile brain in a juror that, hey, by awarding a big judgment against a company, you are not just protecting yourself and your family, but the community as a whole. For our industry, the trucking industry, there is an academy of truck accident attorneys, and they are all about certification and education. They have this was last year. They had a symposium in Austin, Texas, all designed to be able to go after trucking companies. Who are your potential witnesses? How do you get the video data together early? Trucks, a treasure trove of data, understanding the FMCA's safety management cycle. Brokership liability, multiple vehicle pileups, how drivers cheat on ELDs. A big part of what they do is look at how can we show that the actions of a driver were a result of the negligence of a trucking company. So they are really sophisticated. This is what they did last year. And it seems like last year their theme was negligence. This year they have a symposium that will be meeting in October, looking at everything from traumatic brain injury to non-catastrophic cases to when $1 million isn't enough, establishing liability against Amazon, spotting potential product liability claims in trucking cases. Once again, getting to that negligence piece. Of course, they are teaching their folks how to go out there and depose trucking companies, how to be able to make you look bad on the stand. And really, it's designed to make the jurors look at a trucking company and say, you know what, we need to protect our community from this, using visceral images to persuade jurors. They want to make the plaintiff's bar as that safety advocate. And how do they do that? If you have a hero, you need a villain. And this is their final session at their October symposium in Austin, getting jurors to cast the trucking company as the villain in your trial story. And really sad, this is what we're up against. My good friend, Doug Marcello with Blue Wire, he gave a presentation to myself and all my colleagues last month, and he had some great advice. His advice is the safety program that you want to talk about on the stand, do it now. That might mean that your safety manual that might be an inch thick may need to only be a couple of pages. That may mean you need to go and take a look at how you talk about safety to the public and your customers, and take a look at that, because casting you as the villain, casting the trucking company as the villain, what the trial bar is trying to do really belies the fact that as an industry, we are investing over $10 billion annually on safety training and technology. What we need to do is open our eyes. And I'm the son of a gold miner here in Nevada, Virginia City, which is just up the hill from where I live in Reno. The miners, they didn't like the traditional mythological view of justice as blindfolded. Those miners thought it would be better if justice had her eyes wide open. So this is a statue up in Virginia City. If you ever have a chance to come out here, you can go and take a look. She's got her eyes wide open. And really, that is what we want to do with the Mongoose Method. We want to open up the eyes of the trucking companies, of our defense attorneys on those tools and tactics that the trial bar is using to go after you. So it's all about ultimately rebalancing those scales of justice by giving you the same kind of training that the trial bar has been giving to their folks. This is really being proactive. It's not waiting for an accident to happen. It is making sure that before the worst happens, before we're on the other side of a table from a plaintiff's law firm defending our actions, that we are prepared. We want to make sure that we are giving our defense attorneys the tools to beat the reptile theory. We want to have pre-litigation training for trucking companies to identify those traps and trends the plaintiff's bar are using against us. We want to make sure that when you do get in that case, that you know there are resources there that Dr. Kanasky is going to talk about here in a couple of minutes that can help you change the outcomes of those cases so you're not faced with a nuclear verdict. And ultimately, and this is the mission, it's about rebalancing those scales of justice. So what we have done, and this was really kind of interesting for me. I was supposed to go to an ATA legal forum a year ago in Washington, D.C., and who in the hell wants to go to Washington, D.C. in the summertime in mid-July with rats running around the city? At that time, they had just lifted the mask mandate, so that was better. All my flights worked out, so begrudgingly, I went. And I got to meet Dr. Kanasky and saw what he did, saw the training that he would put his folks through when they were faced with a case. And I thought, what if we did this before that happened? What if we were able to give our folks the ability to get better, to coach them to get better, just like the trial lawyers are doing? So when we are faced with these accidents, these crashes that may result in nuclear verdicts, we're going to be better able to defend ourselves. So far, with the Mongoose Method that is less than a year old, we have had trainings in 6 states, or we have had 6 trainings in 5 states. We have a 6th announced in Ohio. I think we have a 7th. It happened after I did this slide in Ohio. So we have been doing this throughout the country. And every time we do one, we're learning what works, what we can make better, what we can tighten up, and it's been fantastic. Now, why do we go this route? I'm a lobbyist. I've been in the legislature for 20 years, which actually kind of scares me a little bit. But in states like Nevada, trying to get something done against the trial lawyers is like Don Quixote tilting a windmill. It is extremely difficult to do. So if we can make our folks better using the Mongoose Method, and I'm going to tell you, this is a tool. This is not the whole cure. This is a tool. I have friends like John Esparza in Texas who has been extremely successful in getting tort reform legislation passed in the Lone Star State. In Montana, in West Virginia, in Missouri, there have been legislative successes. But where we don't have that ability to get that success, either in the judiciary or the legislature, it really is incumbent on us to get better. Now, hey, why do we choose the mongoose? Of course, the trial lawyers for the reptile theory, they use a cobra. And I went back to my, I'm a Gen Xer, so every Easter they play the Chuck Jones Ricky Tikki Tavi cartoon with the mongoose who was protecting his family. A mongoose defeats a cobra because it isn't afraid to go out on the attack. It has an immunity to snake venom. And when you look at that, that's how nature balances the scale. And what we're doing with the Mongoose Method is looking at how nature balances the scale and using that same ideal to move forward. Now, it's kind of fun to see when something really works and when you have something that works. And that became apparent to me just a few weeks ago when the same Academy of Truck Accident Attorneys that has all of the symposiums and the education to sue trucking companies came up with a webinar that's going to be next week that they call Caging the Mongoose, the newest method used by defendants to avoid accountability. Now, hey, that's not what we're trying to do. We don't want to avoid accountability. If we're at fault, we want to take responsibility for that. But we want to make sure that that ultimate verdict is fair, that if somebody is hurt, they are justly compensated, that we are not falling back on this jackpot justice system, which ends up having negative ramifications, not just on the trucking industry, but throughout our entire economy and society. And very blessed to be working with Dr. Bill Kanasky and the folks at CSI. They have been phenomenal about moving this forward. Blessed to have my colleagues from around the country take this on. So we do have the ability to have trainings nationwide through your state trucking associations that aren't just there to help the big carriers, but are there to help the folks that, have one or two trucks and are also worried about what happens if they're on the other side of one of these lawsuits. And with that, I'm going to turn it over to my good friend, Dr. Kanasky.
Thank you, Paul. Very nicely stated. And Houston, we have a problem, all right. We've seen all these verdicts, and I'm not going to spend too much time on this because that's the reason why you're all here. We all know what's going on, and fortunately, there is a solution to much of this, and that's what I'm going to outline for you today. I'm a clinical neuropsychologist by training. For nearly 20 years, I've been studying jury decision making. That's half my job. The other half of my job is working with key witnesses, and your industry would be the corporate representative, the safety directors, and the drivers to prepare them for testimony, particularly deposition testimony. We're going to talk a lot about how that can really determine your fate in the case. But, nuclear verdicts are a huge problem, and nuclear settlements are a problem. And that's when a case gets settled. You have a case that should be settled for $2 million, and you're writing a $5 million check because you've been outmaneuvered. So let's talk about the nuclear verdict / nuclear settlement formula. And by the way, what I'm about to show you is no mystery. The plaintiff's bar brags about this. All right, so everything I'm about to show you, there is no mystery. They like to advertise how they're doing this, and we've been studying this for years and years. I'm going to share some of our research with you. So what is their strategy? Step one, by far, is they are coming after these key defense witnesses in deposition, and they want to absolutely obliterate them, and they're videotaping all these depositions. Now, the problem with that is that in many venues, videotape deposition testimony can be used at trial. And if it's a very poor performance, again, by your corporate rep, by your safety director, by your driver, that's going to put you in a very, very bad position. And if you go forward with that case to the courtroom, this is where a lot of nuclear verdicts happen, because the jury sees these video clips and get immediately turned off, get upset, and that's a real problem when it comes to damage awards, if they get there. But then if you want to settle that case, the plaintiff attorney has no motivation to settle the case fairly, because they're going to say, hey, I've got you. I'm holding all the cards. I've got the leverage. Why would I settle this case for $2 million when I've got all this great stuff I'm going to take to the jury? I can double or I could triple that. And that's how you get your nuclear settlement. So This is early in the case. These depositions are absolutely critical to your success in the case, both economically and strategically. And we'll talk more about that. Secondly, the plaintiff's bar, because of how they do things and because their business, the way their business is organized, their top weapon is they do mock jury research in the form of mock trials, focus groups, and they do them early. They do them early because they got to figure out which of their cases are a winner. Which case remember, plaintiff attorneys don't get paid every 2 weeks like we all do. They're getting paid when they settle or win cases. So they're overwhelmed with requests for cases. So they have to do their homework up front to decide, what cases do they spend time on? What cases do they front money on and invest in? And so they're way ahead of the game on how a jury perceives a case compared to the defense bar, because they are forced to do early jury research to figure out what's really going on. So they know they have their lottery ticket well before you have a loser, and that's something that can and should be changed. And then once they accomplish these two steps, again, their demands will be excessive. Absolutely excessive, because they know they've got you. They know there's no way out. There's no reason for them to be reasonable. They're holding all the cards, and so their demands get crazy. Oftentimes they refuse to settle because, again, they know they have their lottery ticket because they have the testimony. They've done the jury research multiple times. They know they've got a winner. Why would they take a settlement when they can go to the courtroom and get a nuclear verdict? And then again, they want to play the odds at trial under the assumption, which unfortunately is often completely true, that they will have out-prepared the defense by the time they get to trial. And that's a lot of what's going on here. They're going to play the odds at trial that they have out-prepared the defense. They have put in the time, the money, the resources. They've done the homework where the defense lagged behind. Perhaps an insurance company would not pay for such things to properly defend the case. And so when they get to trial, it's oftentimes a complete mismatch, and it's a blowout. What causes nuclear verdicts? Everybody's talking about this. I'm a scientist. I take a scientific approach to this, and we have studied this for years and years and years because nuclear verdicts are not new. Okay, there are massive verdicts in the billions of dollars from the 1980s that we know about, and so this is nothing new. It's just it's nuclear. It used to be called the runaway jury. For those of you that if you saw the movie. John Cusack, Gene Hackman, The Runaway Jury. I believe that was in 2003, 2004-ish. These verdicts have been going on for a while, and we've been studying them for a long time, and we continue to study them. I want to show you what's really proven to be causing these nuclear verdicts. Now, unfortunately, if you Google or you start reading articles or you listen to attorneys, defense attorneys, you're going to get a bunch of things listed that have no scientific proof whatsoever. What I'm about to show you is very data-driven and what we know to absolutely be true. Number one, problem witnesses. If your witnesses suck, the jury's not going to believe a word they say, and they may even want to send a message. So problem witnesses is really, really the number one factor here. And we have total control over that. We all have control over this. And the problem is really been a lack of advanced preparation for the tactics that the plaintiff's bar is using. I mean, these are devastatingly effective questioning tactics versus in deposition. And if witnesses are not adequately trained, they really stand no chance. Even if they tell the truth, it's just they're going to step on every landmine in the field, and that needs to be prevented. Many of these tactics come from that reptile theory that we talked about, which myself personally, I've tried to be the pioneer, to be the anti-reptile guy in the country. And we have largely, we've crushed them, absolutely crushed them. The problem is not enough defendants are investing the time and the energy to get these witnesses properly trained. Ineffective strategies for witnesses. I'm not going to get into pivoting, but that's really just when a witness tends to argue with plaintiff's counsel. And when you argue with a professional arguer, you're going to get your ass handed to you. But ineffective strategies are being taught to witnesses. Many witnesses have emotional meltdowns and go into what we call fight or flight response patterns, which can be very harmful because your witness starts saying crazy things. So we don't want that. And this is really, these are a key set of questions, particularly with the reptile folks. They focus on safety, 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 safety. Okay, so everybody watching this, please get this slide through your head. Okay, safety is not the top priority in your industry or any other industry. That would be impossible. Safety is very important, and there's ways to talk about safety, whether it's at work in the workplace, whether it's in your employee manuals, your training manuals, right? Or particularly at deposition. But I can't tell you how many trucking companies or anybody in the transportation industry that they have these crazy things on their websites, in their internal literature, and even on the walls of the office. Yeah, safety is our top priority. Okay, no, it's not, number one. Number two, it's exactly where the plaintiff's bar is going for ammunition to use against your witnesses. And all this inflated, idealistic safety language, that's what they're hammering you over the head with. So for homework assignments for the whole group, okay, go look at your website, look at your internal documents, your training manuals, make the necessary changes. We can help you with that. But if it's like, safety's number one, safety's top priority, if that's all over the place at your company, you're just asking for trouble, and it works every time. It's shooting fish in a barrel for the plaintiff attorney. We talked about these safety rules. Well, the safety rules come from your stuff. You're the folks providing the plaintiff attorneys with the ammunition to shoot back at you. So again, there's ways to correct that, ways to get around that, but it takes a very proactive approach, not a reactive approach. And this, funny enough, someone from this guy's office tried to sign up for this seminar. I plucked that out of the attendance list. Thank you very much. But for example, Tim Dollar is a top 5 trucking plaintiff attorney in Kansas City. And I took a little picture of one of his deposition scripts. These guys have a script, it works, and they share it with each other. But here's what I got. I got the antidote. Okay? I have the training to prevent all these yes, 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 yes answers from ever happening, and it derails this. It really, really derails this reptile attack. Protects your witness, right? And then we have effective testimony that cannot be used against you at a future settlement conference, at a future mediation, and particularly at trial. All of this, 100% of what we're talking about, is fully preventable with the correct and proactive, aggressive approach that's really never been there, not just for trucking, across the defense industry, across different industries. It hasn't been there, but now it's starting to work. And the fact that they're having an this is an anti-reptile seminar. They're having their anti-mongoose seminar. I mean, I'm so proud. I mean, Paul Enos is very, very proud. I can't tell you the joy that comes to my life when the enemy is so scared they have to have their a seminar, and trust me, more will come. Do you want to know why? Is we're making waves. Okay, they know we are figuring this out. In fact, they know we have figured it out several times, right? And they may have the lead now, but we're certainly catching up. Now, this is right from the reptile manual, which I have, and I've read over 200 times. I've memorized the whole thing. But this is back to this nuclear settlement thing. Yeah, they want to defeat you early. Okay, they want to make you submit. Believe it or not, the vast majority of plaintiff attorneys, they don't want to go to trial. They have to wait years for trial. But if they can get that early leverage, that early lead, and they start pushing that fear button, right, that we all have, particularly within the insurance company, within the trucking company, and then the defense attorney, they can create this fear because they know heads are going to roll, right? This is how the nuclear settlements happen, is they create such a imbalance of leverage in the case. You have the owner of the trucking company, you have the insurance claims person, you have the defense attorney, and they all know somebody's losing their job, right? Somebody's losing their job if we get nailed here, and they end up writing a check to get rid of the case. But that's what they want to do. Whose head is at stake, right? The ever-present guillotine of the profession. That's why they fight so hard so early, because they'd rather get their money from you in 2 years as opposed to 5 years and waiting for trial. So early intervention is the key here, being very aggressive and proactive, not wait. What I always say, if you're in a 12-round fight, okay, you're in a 12-round fight, if you start throwing punches in round 8, you're going to get your ass kicked, right? You can't do that because why? Because the other guy's beating you up the first 7 rounds. So why don't you come out of your corner swinging in the first round? Okay, it really increases the odds of success. If you want to learn more about Reptile, you can Google me, and all these articles will come up. They're free, or reach out to me. Happy to send them to you. But we've been spending years and years publishing How to Beat the Reptile. It's out there. It's free. And so I really encourage you to read this stuff. All right. Specialized training. So what do we do? That's the first question. What do we do? Well, we have training programs for safety directors, risk managers, experts. A lot of truck drivers are foreign born, right? Got a training program for them. You got to get them ready for that deposition so they don't just torpedo your case. And that's what we have. And boy, it's been highly effective. I mean, highly, highly effective. Now, number 2 cause of nuclear verdicts, egregious conduct. Now, this happens in a lot of cases where these jurors do get mad and they want to punish instead of compensate. And everybody remembers the McDonald's verdict, right? A spilled cup of coffee leads to a $1.3 million verdict. That was 25 years ago. But these jurors were not happy, and they thought McDonald's, and this is all from the trial and deposition testimony, is these jurors got pissed. And look, I mean, they thought McDonald's had a callous disregard for the safety of people. And another juror said, the facts were so overwhelmingly against the company. And so, what we're getting at here, so they ended up, the verdict was like 1.5 and compensatory. I think the total came out to $3 million when they awarded punitive damages. And the reason why is there's a lot of bad stuff that happened. In your industry, it's driver fatigue, it's driver intoxication, it's falsifying driver logs, it's having a shitty training system and hiring process and cutting corners. It's not having the available technology. When you have all those things in your case, it may not play well to a jury. But again, the only way to test that and to see if it's fixable is by doing that jury research, doing it early, figuring out, do I have a winner or a loser? And the earlier I find out, the less of the odds that we're going to have a nuclear settlement or a nuclear verdict. Now, listen, some cases are bad. Okay, some cases are bad. Some cases are not worth the fight, and you need to know when and how to settle those cases, get them resolved as early as possible. But other cases, that's not the case. But how do you really know? Here's the key. You don't. You don't know unless you do the research, do your homework to find out what type of case you truly have. Because you may feel you have a good case, but if the jury doesn't, you're going to pay. Cause number 3, punitive jurors. Jury selection is really important, and this is kind of more of a defense attorney slide. But what we see, and we do a lot of jury consulting, that's part of our jobs, but we see a lot of cynical, resentful people ending up on juries because they were not successfully struck in the jury selection process. And we also see some defense attorneys use jury selection processes that are not scientific at all, as you can see by the quotes right here. They kind of go on their gut or gut feelings and stuff like that when they select jurors. Yeah, if you have a bad jury, you're going to get nailed. Period. So putting resources and time into how do we pick the right jurors, a lot of what the jury research tells you is not how good or bad your case is, maybe what the value of the case is at the jury level. It shows you the types of people that are going to be pro-plaintiff and high damages. Well, if you know what those traits are, you can take those into jury selection and use those to strike prospective jurors. All right, cause number 4. Here I really can't help you as much as I can on the other stuff because some places are just really bad. And some of these venues, not only are the jurors already pro-plaintiff by definition, the judges are pro-plaintiff. And that here's some examples for you. And that list is growing, unfortunately. But, you have to go to trial in one of these venues. It's very, very challenging. Now, we still win cases in these trials, but the amount of work and the amount of effort oftentimes is more than other venues. Number one, I'll tell you that. But number two, you really need to reconsider, do I want to go to war in this venue? These venues are very, very tough. And so I think the amount of communication, the amount of work on the defense that needs to be done, particularly in one of these venues, is absolutely critical because the cards are stacked against you. They really, really are. And again, when you have I can help you with jurors. I can help you with witnesses. I can't help with your judge, folks. Okay, you've got a shitty judge that's going to rule against you all week. That's really, really tough. But again, there's a lot of work that can be done to get that case assessment and early see what you're dealing with, and to at least do your best to keep the damage as low as possible. But again, trying to resolve these cases is usually the wise thing to do. And finally, this is kind of a tough slide, particularly when I give this presentation to defense attorneys. Defense attorneys get upset at this slide. The irony behind that is that defense attorneys gave me the information to this slide. They gave it to me and said, we want you to get the word out because, in any industry, there's dirty little secrets nobody wants to talk about. This is one of them. And it's the fact that plaintiff attorneys and defense attorneys are wired very differently. Paul just told you the amount of training that plaintiff attorneys get is just beyond ridiculous. It's mind-boggling. It's staggering. Where the defense attorneys really don't either get the training or they don't have the opportunity for the training. And that's been a real problem. And so you've seen this evolution of the plaintiff's bar, and particularly their younger attorneys are far more experienced and talented than their equally aged defense counterparts, which is going to create a whole new problem in the next, I would say, roughly 7 to 10 years. That's going to be a problem, but I think that's a different webinar, folks. So let's talk a little bit about this. They have learned from each other. This is a group of people, these plaintiff attorneys, and again, hats off to them. Hats off to them. They did their homework. They did their jury research. They learned what worked. They learned what didn't work. And here's the thing. They shared all that with each other. So one of the key factors with the Mongoose Method and our close relationship with folks like Blue Wire is exchanging information between companies, between attorneys, between insurance people to help each other. The defense, by definition, just hasn't really helped each other in the past. That better change because these plaintiff attorneys, They have their listservs. They go online. They help each other. They run scenarios by each other. They give scouting reports on various defendants to each other. It's a very sophisticated and coordinated group, and the defense is not. I really, really, truly think that can and should be changed. So you see this very aggressive questioning at deposition of witnesses. Again, we have the training program. That's the solution for this, so that your witnesses can and should be bulletproof at deposition. But again, that takes work. That takes time, and it takes money. Yeah, there is a cost to that, but the return on that investment is just a no-brainer. They're calling defense witnesses very early at trial in the plaintiff's case, try to skewer them in front of the jury. Well, we have a training program to deal with that. And again, if the deposition is effective, it makes the trial testimony even more effective. They are certainly pushing the ethical limits, not just at trial. I put a trial here, just throughout the case. They are pushing the boundaries until they get disciplined by a judge or the court. It's incredible how they will push these boundaries. And then again, you got those reptile theory tactics that are so highly effective when you're going up against a defendant that doesn't have the proper tools to defend against it. It's really an unfair fight. It's really, really an unfair fight. I've been sick and tired of it for a long time. I mean, you have to understand the reptile theory and all this stuff we're talking, this all came out in 2009. It's 2022, folks. The good news is we've studied this right to the molecule. We've developed all of the counter tactics to destroy this. And we destroy it literally every single week. I work on a reptile case and we beat them. The problem is there's a lot of cases out there. And it's frustrating to me, particularly when I get a call. I get a call right before trial. Oh my God, we're going to trial, case didn't settle. And then they send me the depositions. And they're disastrous. And the whole thing's just set up for failure. So if you get anything out of this, the number one theme here that Paul and I are trying to explain is how you handle things early in these cases determine your fate. Determine your fate, right? College football is about to start this week. Well, technically week 0 was last weekend, but now you got week 1 coming up here. And, if your team is down, your team is down 42-7 at the beginning of the fourth quarter. Well, there's still another quarter of football to play with, right? I mean, so there's still time. But you're down 42-7, damn it, and you got 1 quarter left. That's the position I see the defense just week after week putting themselves in. And then they call me like I'm the backup quarterback or something. They want to bring me in off the bench to try to come in and help, and I'm like, guys, we're down by 35 points. Like, what do you want me to do? All of that is completely unnecessary, and that reactive philosophy has been around for a long time on the defense side. It has to change, or there's no chance of winning. And again, these are just very different people. They're very, very different people. They talk to each other. They share things. They're highly sophisticated. They invest in this training to defeat you. And you saw what Paul showed you about some of the seminars they have coming up. Listen, we're dealing with an adversary that is very, very aggressive and highly motivated to win. And we, meaning the good guys, us, and me and Paul in particular, and why we're bringing this approach out is the tools are there. The system is there. The philosophy is there. Okay? Oops, I don't know what happened there. Excuse me. The philosophy is there. And we can, sorry about that, guys. We can beat them. If I would just get my, sorry. All right, so success. Priorities in discovery. Crisis response. You have to have a crisis response time. plan, okay? Immediate post-incident meetings and research, and I'm just going to go over these quickly because each of these is a different presentation, right? Pre-deposition, what I would call as a scientist, neurocognitive training for the key witnesses is really, really important. And that jury research, earlier the better, so you figure out what is going on in your case. That is very, very important. If you wait, remember, if the other team's up by 4 touchdowns, you're going to be in trouble, and that is really what is happening here. Again, so let's kind of take these one, but crisis response. We do a lot of, we have a specialized consultant on staff that just deals with crisis response plans, what you're going to do with the media. Boy, a lot of headaches there, right? A lot of headaches there. How you're going to communicate with certain people and really proactively managing your response after something bad happens. A lot of headaches occur because there is no crisis plan. There is no rapid response team, and then things get out of hand pretty quickly. Having meetings, getting the communication action plan set, getting inside, outside counsel, hopefully, somebody like me, looped in immediately, and make a plan from day one. You start winning or losing your case day one, okay? Day one. And, really ensure that, all the people, all the individuals who are expected to be involved, make sure everybody knows, who's got what role, what's going to happen next, and maintain that communication over and over and over. That's going to be really important. This is really, where a lot of the heavy lifting that I do comes in, me and my team, is the pre-deposition training, again, for your corporate reps, your safety directors, your risk manager, your driver, to give these witnesses, I got to rewire some brains here with each of those folks, but to give them the tools and the weaponry necessary to survive that reptile attack at deposition. It's coming. It's coming. We know it's coming. The bad news for the reptile folks is now they're highly predictable. Okay, they're highly predictable. We've created countermeasures for all of their tricks and traps, highly effective, but it does require a lot of effort and training up front. Jury research. Now, this is not cheap. This is not cheap, but this is really where you're going to get a lot of your key answers about what is the case worth? Where am I at on apportionment of fault? What percentage of a jury is going to try to nail us on liability? What percentage of the jury doesn't think we did anything wrong? Getting those answers early. Knowledge is power. Knowledge is power. Knowledge is money. Because how you handle that file, how you handle that case, how you hire various experts can be completely dependent on this research. If you don't have any of these answers, how are you making decisions? Think about that. If you don't know how a jury thinks about your case, how in the world are you making decisions about your case? How? What, your experience? Right? Your trial attorney's experience, right? Well, guess what the bad guys are doing? This slide. This is what they're doing. They're doing their research to figure out, how do I win a trial? How do I get a nuclear verdict? How do I get a nuclear verdict against this trucking company? They're doing multiple versions of these, and they're doing them repeatedly to fine-tune things, so by the time they get to mediation or trial, they'll have that 4 or 5 touchdown lead. There's no reason for that. This should be a tie score at all times, or maybe you should have a couple touchdown lead, okay, if you're playing your cards right and if you're being aggressive. So let's summarize everything I just talked about. Yeah, I can speak for 3 days. Like, literally, I have 3 days worth of material on this, and they gave me 30 minutes. So I went pretty fast. I apologize. But let's kind of summarize what Paul and I just discovered. These verdicts are preventable. These settlements are preventable. They are. And a win, something interesting happened in Los Angeles a couple weeks ago. The Kobe Bryant verdict, right? His wife, and another spouse of passengers killed in that terrible helicopter crash. And the first responders had taken videos and pictures of the dead body, right? And so you just heard, that was a $31 million verdict. Well, the plaintiff attorney in that case asked the jury for $75 million. And talk about egregious conduct. So I think the other thing that we have to do as a defense is, what's a win? What is really a win? Meaning, if you end up going to trial and they ask for $100 million and the jury comes back at 25, is that a win? I would argue that's a win in that particular circumstance, right? Other times, you're just looking for that defense verdict, okay? But again, doing the homework to figure out what are your chances of those various outcomes. If you don't do the homework, there's no way you're gonna really ever know. Defeat reptile every week. Every single week we defeat them. You just need the right tools. Got to be proactive. This is the Achilles heel of the defense bar. Got to be proactive. You can't wait around. And again, your decision should not be made on gut. Gut feelings aren't going to get you anywhere. We have scientifically valid, research and programs and training programs that deliver superior outcomes. And if you use them, it's in your best interest. Again, advanced trial tactics. You got a very talented, motivated, and aggressive plaintiffs bar. Period. Again, hats off to them. They've put the work and time into it, and it's paid off for them both literally and figuratively. And that is my section, and we can go back to the moderator and get some Q&A. Thank you very much, and let's do some questions.
Okay, thank you. We do have some time remaining, and in just a moment, we will get to some of those questions. But while we're getting them together, I want to remind you that this webinar is being sponsored by PrePass, the nation's premier waste station bypass service provider. Only PrePass offers you a choice of bypass technologies, either with a transponder, the PrePass app, or both. The PrePass app works on iOS and Android devices, or through a telematics or routing systems integration with Garmin, Geotab, Omnitrax, or Pedigree technologies. PrePass also provides electronic toll payment services, driver safety and productivity alerts, and easy-to-use carrier safety score and tolling dashboards. Visit PrePass online at prepass.com. Now, let's answer a few of those questions that came in during the presentation. First off, before we get going, Bill and Paul, would you tell people how they can get in touch with you if they have further questions or want further information?
Paul, you go first.
Sure. They can reach me at nevadatrucking.com. We have a Mongoose Method website, mongoosemethod.com, where you can go and email us questions or Nevada Trucking. I'm really easy to find, so just go ahead and Google me. And if I don't answer my cell phone, which is out there for every politician and person to get, you can always send me a text.
Yeah, same here. I'm very easy to find on LinkedIn. Just Google me, Bill Kanasky. If you want to go to courtroomsciences.com, we have articles. We have our weekly podcast, and which every Monday morning we cover a lot of the things that I talked about. Or look me up on LinkedIn, and happy to get an email or a phone call from you.
Okay, great. Thanks for passing along that information. Okay, let's get into some of the questions. First question, how should trucking companies prepare before we have an accident or a lawsuit?
Well, hey, I think that, the Mongoose Method gives you a phenomenal opportunity to be able to do that, in a way that isn't a huge cost to your industry, like when you're in the middle of a lawsuit. So, it's making sure that you have your person that's going to talk, your corporate representative, your person most knowledgeable. It may be the safety director, it may be the CEO, it may be human resources. You want to pick that, and then just making sure that those folks are trained and really kind of being aware of what the other side is doing and how they're targeting our industry and how they're going after some of those places where we have some weak spots and stealing those, putting armor on those, So they're not weak spots anymore. And once again, I'm going to quote my good friend Doug Marcello. Think about the kind of safety program that you want to talk about if you're on the stand, and start doing that now. A lot of folks have very lengthy safety policy manuals. A lot of folks think, hey, we're going to go above and beyond what the regs tell us that we should do. And that's great, but make sure you're doing them. Make sure what you're telling your folks you should do or you expect out of them is actually what you're doing.
Okay.
Agree.
Okay, great. Thank you for that. Another question for you. How can a smaller carrier who doesn't have the resources of a big carrier protect themselves?
Well, that's really who this program was designed for. You're right. If a big carrier gets in an accident, they have a tremendous amount of resources. They may have in-house general counsel. They may have, their contacts with folks like Dr. Kanasky, their jury consultants. But for a small carrier, that is difficult. And, really, that's one of the things the Mongoose Method set out to do is through your state trucking associations to be able to offer our small carriers this kind of training at the fraction of a cost that a big carrier might pay when they are addressing this lawsuit. So, once again, it's being proactive up front.
Okay. This one goes back to one of the points earlier in the presentation. You're talking about safety being mentioning that safety is a top priority. If you say when you're saying safety is a top priority, what should the person say is their company's top priority then if it shouldn't be safety?
There are no priorities. It's the word priority, which is the trap there. And you should avoid that word at all costs. Because priorities implies a list, okay? And priorities change based on circumstances. That's not how companies function. Companies should have values, core values, goals, and they're all equally important, okay? So customer service is one of those values, being effective, quality services, safety is one of those values. Is profit and revenue a value? Hell yeah, it is. You can't run away from that. You're running a company. All of these things are important. And so when the witness, and again, we have a program on this, so I'm cutting this way short. But essentially, what your witness needs to say is, safety is one of the many important things at the company. Absolutely. But you don't want to say it's the top priority, because if you do, you walk right into the reptile trap, and every other question after that is going to be problematic. Get away from the word priority. In fact, I've seen many trucks these days recently, because somebody's gotten the message, and on the back of the truck, I've seen things like, safety is our goal. Yes, it's a goal. It's not the top priority. Okay? It is a goal. It's something that's very important. It's something that the company values. Avoid the word priority at all costs. Because it's not true. It's not true is the problem.
Yeah, a real world example of somebody being in a trap on that is, hey, safety is your top priority, and that it's harder for a truck to operate on slick roads. Why did you send that truck out in the rain? Apparently safety isn't your top priority. I mean, those are the kind of real world traps that might sound silly, but those are the kind of tactics that the plaintiff's bar has used very effectively against our industry.
Absolutely.
Okay, thank you for clarifying that. That's a helpful response. Next question. Should an owner-operator who has drivers get statements from them as soon as an accident happens, and how can that be used against the defendants?
Well, I think that's a legal question, I think, and whether that's going to be written, is that going to be oral? I do think getting with the driver as soon as possible, and sometimes they've already talked to. I mean, that's a really, really complicated legal issue, but I can say this: getting with the driver and talking to the driver and taking care of your driver. That's a whole nother webinar I can do, is what you need to do with your driver, because these drivers are having a lot of emotional, it's a traumatic experience, being in an accident, and how you handle them from that point forward is really, really important. And then they may have some mental struggles with that going forward. I'm going to defer that question because I think that's really an attorney question. I also think that may vary state by state on what the laws are in each state. My concern from being a neuropsychologist is the mental health of the driver, and addressing that as early as possible, and then continually checking in with them, weekly or monthly after that, to make sure that they're doing okay.
Okay. Another one, do toxicology reports have much weight? As an example, like alcohol levels in a plaintiff.
Yeah, 100% absolutely. They absolutely have a lot of weight. And then when jurors hear about toxicology reports, whether it's plaintiff, defendant, or if it's a multiple vehicle accident and you have co-defendants or whatever, it's a science that jurors understand and jurors believe in. Now, that's from a liability standpoint. Are all jurors going to become very punitive? Well, I think it depends on what it is. Was it? I've had cases in which the driver on the toxicology report had pain medication in his system. And he had the pain medication in his system because he had back surgery and he was taking it and it was prescription. He wasn't abusing it. And so but it was in his system, right? That's an issue at the jury level. But is it the same issue as, methamphetamine? No, it's not the same issue, right? Or a combination of other things, or marijuana. There's the way these things are perceived that's why the jury research is so important, because is it important? Yes. How important is it is really going to depend upon that driver's specific circumstances.
Okay. Is it a good idea to file a suit against the other person first, especially if the other person is at fault?
Ask an attorney. I'm not an attorney. That's a legal question, and I think the ability to do that will vary from state to state.
Okay. All right. Another question then. If something does happen, is it imperative to hire or consult with an attorney versus allowing the insurance company to be the liaison?
Boy, that's a oh boy.
And
it's very interesting.
I kind of go back to my good friend, Randy Gilead, who, and Bill talked about how the defense bar is conservative. And, it's really because the incentives are different. The trial lawyers can afford to invest in these cases because there's potentially a huge payout on the end. On the defense side, on the insurance company side, it's all about cost containment. It's all about trying to contain that liability. So, it is a little different. I will tell you that reaching out to your insurance companies, having these conversations with your insurance companies beforehand is imperative. We are working with, we've had some insurance companies attend our Mongoose Method trainings and had conversations about, that relationship and, who controls what. So I think it's very important to have that good relationship with your insurance company. And, make sure you're watching out. And, we know some of the factors that are going to have a potential for a nuclear verdict. And that's something that actually put in that study. And I would encourage everybody to go to truckingresearch.org and check that out. You can see what some of those factors are, making sure that your broker, that your insurance company knows that, I think is imperative too. And sometimes that's going to be on us to educate them in terms of what that exposure is. Okay, well, great. That was a good detailed answer to that question. And
just want to kind of wrap up. That is all the time we have for today. I did want to mention that if someone did ask a question that wasn't answered, you will be answered by email after the event. Sorry we couldn't get to all the questions during the webinar today, but your question will be answered following the event via email. We hope that you all enjoyed today's webinar. I want to again thank PrePass, along with Paul Enos of the Nevada Trucking Association and Dr. Bill Kanasky Jr. with Courtroom Sciences for doing today's presentation. I also want to mention that this webinar will be available on demand on the PrePass website, and that's at prepass.com, as well as the heavy-duty trucking website, and that is at truckinginfo.com/webinars. Thank you, and we hope you have a great day.
Thanks, Jay. Thanks, Bill.
Thank you.